Mr. Rangasayee Ramakrishna, please.
So today I will follow a very unconventional method of intervention. I would like to give about 8 or 9 bullet points of recommendations, and then I will come to the narration, because every time I'm rather afraid of your bell. So everyone has talked about the large-scale pendency in the courts, and so the courts have resorted to some method of solving this thing by saying that we are disposing. I'll come to statistics later on, but phony figures as to disposal are being given. So we should aim, first bullet point is, we should aim at settlement-oriented delivery of justice rather than disposal-oriented delivery. Second thing is, there is a lot of procedures and legal mumbo-jumbo which we inherited in the colonial era, and they still continue. I think these agents' tables should be cleared. There are a lot of pre-hearing formalities inherited from the colonial era, and in fact it takes a hell of a lot of time before the case goes from the registry to the benches. So I think we should bring a lot of information technology into these areas in a substantial manner. In a country which boasts of their IT supremacy, we still have not thought of online filing of cases. I think we should do that. There should be meaningful digitalization. We should also do away, at least in appeals, with the reconstruction of the so-called paper books. The third point is, there are very good experiments in UK and in the state of Victoria in Australia, where all these procedures and formalities, pre-hearing formalities, they have been converted into a corporatized structure. This is called, in United Kingdom, it is called Her Majesty's Courts and Tribunal Services. I think we should study this procedure and introduce a system by which all the back office formalities are taken over by a public sector organization, and the judges will be left only for hearing the cases. Then we should actually try for a cheaper and speedier dispute settlement mechanism by, actually every department has experienced retired people who can be engaged in settling all these disputes rather than go to the court. In fact, my complaint is that the state is a predator. 40% of the litigation cases are cases in which the state is a party. So there should be, in fact, I feel that you should have a ban on the state filing appeals in cases which concerns its employees. Okay, the first case, let it be there, but there is a practice of appealing and appealing again by the government. This should be stopped. Then we have tried many other things like tribunals, arbitration, and other quasi-judicial bodies, but they also emulate the same old practices, and they have less of law, and they have more of law and less of justice. There is a huge gap in staffing. That's a fact which I'll come to the statistics later on. So why don't we consider and think in terms of something like the army, where you give short service commissions? Why don't you recruit people for judges for a short period, contractual period, 2 years, 3 years? You do that thing and dispose of these cases. In fact, I don't know why we have not had a commission like the Union Public Service Commission for doing all this recruitment of jobs in the judicial service. When we from the colonial era, we inherited when the Indian civil service, it had one executive branch and one judicial branch. And why don't we do some such thing and fill up all these gaps? Then we have got very good traditions earlier. We had Nyaya Panchayats in the 60s. We have abandoned them now. We had Lok Adalats, small traffic offences and family disputes. This all can be looked after by these Lok Adalats. You can engage young law graduates, fresh law graduates, to deal with these cases and dispose of them. Then I come to arbitration. Arbitration follows the same set of conventions and procedures, and many arbitration cases last for a longer time than even the courts. I think we should have institutionalized arbitration rather than ad hoc arbitration. For instance, like the Diamond Merchants Guild, which decides its own cases. Then, one last thing, sir. My heart bleeds when I see old people who should rather spend that time, enjoyable time with their families, or look to their ailments and go to the hospitals. They spend time in the courts. And there is no system of fast tracking of these cases which involves senior citizens. I think there should be a rule, strict rule, not being left to the discretion of the courts, that there should be fast tracking of cases in which senior citizens are involved. Now I'll come to the narration. We have a reputation of having excellent track record in common law. We have a fiercely independent judiciary which brooks no interference by the executive or the legislature. Consequently, it is its own master of how to conduct its business. And in fact, therein lies its Achilles heel. Over years, it has degenerated into a structure that cares more for the letter of the law rather than the spirit of the law. The net impact is that the system fails to render justice. Now, although we boast of our common law traditions, here is a finding, the latest finding of the World Bank 2015 survey of ease of doing business. In this, India ranks the last three. Out of 189, it is at number 186, only 3 notches above that, of which countries? Angola, Bangladesh and Timor. What is the subject? In the efficiency of contract enforcement. This World Bank report is based on a very detailed study which they made of our courts here. The study says that in Hyderabad, you need 770 days to enforce a contract. After 46 procedural steps, costing 17.8% of the disputed claim. This is Hyderabad. And in Mumbai, you need 1,420 days, and that costs 39.6% of the disputed claim. This is the justice we are rendering. There is no predictable pattern of procedure or system that is followed on a uniform pattern even among high courts. Different benches in the same high court will give different interpretations of law, with the result that litigants fall prey to lawyers who can manage favorable benches. I have seen cases which get stagnated in the registry itself for decades. Once you are lucky enough to reach a bench, the average time of pendency is 15 years. In 2013, the pendency of cases in the district courts was 2 crores 76 lakhs. The pendency in high courts was 46 lakhs. And in the Supreme Court, it was 66349, totaling up to 3.25 crores of pendency of case. Now, so the court said that let us expedite disposal. So in 2011, there was a Kapadia committee which claims that 2 crore cases were disposed during that year, leading to an average of 1,200 cases. I'm sorry, please. I'm giving statistical details. 1,200 cases annually per judge, which is 100 cases per month, 3 cases per day, assuming that they work 24 into 7, 365, but they don't. They have long summer vacations, they have long puja vacations in Kolkata, but if you assume that they work 365 days, this is the figure, that you are disposing of 1,200 cases annually. What is this disposal? This disposal means I refer the case back to the lower court. This is disposal. Now, I get reminded of a very amusing incident when earlier in my bureaucratic days, one day in the last day of the month when everybody is busy working on how much disposal they've done, I went to my senior officer, who was an ICS officer. He said, no, don't disturb me today. I said, what are you having? I'm disposing, I have to complete the disposal. What he did was, every file has flags. So he took the flag, threw it out and said, where the hell is flag A? He disposed it off. This type of disposal we are doing in the courts, and we are not really settling the case.
Thank you, Mr. Ramakrishna.
5 minutes.
5 minutes. Come on, please. Time is already.
Okay,
At
okay.
least we have to raise by 7
Okay, I'll try to.
There are
I'll try
more
to.
members. The minister has to reply. Please. Take only 1 more minute, please.
Sir, I'll come to that example of Australia and UK.
Just only 1 minute.
UK and
One
Victoria
country
State.
example will do. One country example.
UK and Victoria State in Australia have found a solution to get courts getting overburdened with procedures and formalities. UK has innovated by creating an organization, public sector, called the Her Majesty's Courts and Tribunal Services, for taking on the back office provisioning of formats and procedures in courts. I think this is something worth emulating. Now,
Please, Ramakrishna ji, please conclude.
all the above yields the system get replicated in our
You
system
made
of
your points very well.
ad hoc arbitration, and we should prefer institutionalized arbitration.
Given enough statistics. Thank you very much.
Okay, thank you.
Thank you very much.